So, in this class, we'll discuss the third important treaty maxim, that is pacta, tertis, nis, nocent, nis, portion. And this particular principle regulates those parties who are entered to a treaty and those terms and conditions are binding over them and not over a third party or state without its consent. The Permanent Court of International Justice, in the leading case German interest in police upper Silsila, observed that a treaty only creates law as between the states which are parties to it, and in no case rights can be deduced from it in favor of third state. But under certain circumstances, rights arising out of a treaty are conferred on third states and parties. According to Professor Hans Kelsen, regarding the treaties by which state servitudes are established or on protection of minorities, as for example the treaty between Allied and associated powers on Poland and Czechoslovakia, or treaties on Strait or Channel, or a peace treaty like the Treaty of Versailles and the peace treaty with Italy, Allied and associated powers in case of the broken diplomatic relations with Italy by United Nations. This Latin maxim simply means a treaty does not create either obligation or rights for a third state without its consent. Even the International Law Commission observed as a general principle of law of contract as well as in relation to sovereignty and independence of states, a treaty obligation does not apply to a third state who is not a signatory to such a treaty. So also, Article 34, Article 35 and Article 36 and 38 of Vienna Convention on Laws of Treaty 1969 acknowledge this treaty principle, but the convention provides certain exceptions as the international community being more integrated day by day, so to accept the principle has become unavoidable in such circumstances. Vienna Convention provides that a third state may expressly accept the obligation in writing or the right to give in to third state will be presumed as an assent so long the contrary is not indicated, as these provisions are provided under Article 35 and Article 36 of the Vienna Convention on Laws of Treaty. And as per Article 38 of the Vienna Convention on Laws of Treaty, a treaty may be binding over non-member states or third parties if it creates customary rule of international law. Even Article 2 of the United Nations Charter obliges all non-member states to act as far as necessary to observe in accordance with these principles for maintenance of international peace and security. Even the International Court of Justice observed that the Convention on Genocide, Human Rights, Environment, Laws of Warfare, the Convention on the High Seas as parts of customary rule of international law may be applied to non-parties as well. Among those, the Geneva Convention on Laws of Treaties and also the Geneva Convention of 1949 relating to treatment of prisoners of war, wounded, sick, and shipwrecked persons and treatment of civilians, their properties, religious places, monuments, etc., become international concern and become part of the rule of customary international law and are applicable to all members and non-members, even to neutrals in war for maintenance of international peace and security. And in our next upcoming video, we will discuss another important treaty, MAXIM, that is Rebus Stantibus.